Hi everyone, and welcome to our discussion today on everything you need to know about SaaS agreements. My name's Paul Wright. I'm a practice leader in our corporate and commercial team, and I'm joined today by my colleague, Jess Anderson. Today, we're going to talk you through a couple of housekeeping points first. So before we begin, please note that you'll be emailed a copy of this webinar recording on its conclusion. As we go through, please submit any questions you have in the chat box. We've got some time allocated at the end to answer them, and we'd love to talk through any questions you have. And if you have the time, please complete a short survey at its conclusion. A brief overview of what we're going to talk about. We're going to start very broad and just talk about what is a SaaS, choosing the correct SaaS contract format. We'll spend a bit of time talking about structuring payment, and then we'll talk about some various risk and liability issues, particularly around IP and privacy, how best to manage those. Finally, we'll spend some time running through a Q&A, and then we'll give you a brief overview of the Pro membership that LV offers to its clients. Over to you, Jess.
Thanks, Paul. Okay, so we're starting off with just basically covering what is SaaS. So SaaS stands for Software as a Service. It's basically a software licensing and delivery model where the software is licensed on a subscription basis, and it's centrally hosted and made available via the internet, so you don't need to download it. Some common B2B SaaS examples that you might have heard of or that you might have used include SurveyMonkey, Slack, MailChimp, Zoom, Salesforce. So as a SaaS business, you're going to want to make sure that your clients actually pay you. And you're also going to want to put yourself in a position where any liability or any risk that you have in operating your business is limited or at least reduced, and your SaaS agreement can help with this. Okay, so first things first, you really need to decide on the format of your SaaS contract. We're all familiar with a business needing a set of terms and conditions or a contract, and a SaaS business is no different. So we often refer to this contract as a SaaS agreement, but it can be referred to as lots of things. So terms of use, terms and conditions, a license agreement. It's less about what it's called and more about what's actually in it. And there are different formats of SaaS agreements, and we usually refer to these as online, also known as click wrap, or offline, also known as hard copy. So online or click wrap SaaS agreements are those where you go onto the business's website, you sign up for the product, and the terms and conditions will appear with a checkbox, usually at the time where you're filling out the payment details, and you accept the SaaS contract by ticking a box. So if you choose to set up your SaaS contract this way, it definitely has its benefits. It can be less admin work for you, as your client can just sign themselves up. You'll have a really good record of what terms your clients have actually signed up to. And generally in this sort of scenario, you'll have all of your clients on the same terms and conditions, so it's easier to manage. So we think online terms work really well where you're not necessarily going to negotiate the terms and conditions, and where you don't offer bespoke packages for different clients. It's more of a take it or leave it approach. So on the other side, we also have offline contracts. So these are your typical contracts that we've all seen. Traditionally, they may have been printed out and signed with an execution block. These days, we also see these contracts being executed electronically through online document execution platforms such as DocuSign, and that's perfectly fine. So the difference with the offline terms is that generally there's a schedule or a table with all the commercial details, and you'll need to fill out this table for each customer. So this table is going to have each party's details, the inclusions, the price, the payment terms, all those commercial things. And we find this works really well for businesses where you're not necessarily offering a one-size-fits-all approach, and you want to offer different proposals to different clients. Or, it works really well where the agreement's going to be negotiated. So we always encourage our clients to have a think about how you want your SaaS agreement to be incorporated in your sign-up process before you actually get started with drafting it. And sometimes our clients require both an online copy and an offline copy. For example, you might want most of your clients to sign up online. You know, it's super easy, but you'll have larger enterprise clients that are prepared to spend a lot of money with you, and you want to perhaps negotiate those terms. And so you might have an enterprise version or an offline version of your SaaS contract that has different terms and that's negotiated with that client. Okay, so once you've decided on the format of your SaaS contract, then we can start thinking about those more commercial details like structuring payment, and Paul's going to discuss that side of things.
Thanks, Jess. Yeah, so as Jess mentioned, I mean, structuring payment is obviously going to be really important. It's going to be really important for you as you start a new business, getting that business cash flow positive. And obviously over the long term too, cash flow and revenue is going to be really important for valuing your business. So it's very important that you think about early on how best to structure it to maximize that in the short run, but also to think about the flexibility over the long run. So the very first question, and Jess touched on this in terms of structuring the various contracts, is whether you're going to be marketing to enterprise under a B2B model or marketing to consumers under a B2C. And of course, you know, maybe in certain businesses, you may be targeting both under different segments or approaches. Once that decision's been made, then there's a fundamental decision about, well, how are you going to be billing your customers? Are you going to be billing them on a weekly or a monthly or an annual basis? And similarly, will they be paying in advance of each of those billing cycles, or will they be paying in arrears? It's pretty obvious that you know, signing up customers to pay in advance on an annual basis is going to be really great for your cash flow and really great for your revenue. It's going to lock those customers in for a substantial period of time. But you've got to weigh that up on whether that's the best approach to the market and whether actually you may generate more leads and more customers by offering more flexibility, for example, offering weekly or monthly packages. And then, of course, you know, there's a lot of flexibility here, and that's one of the great things about the SaaS model is that you're able to structure it in a particular way. So you may offer a standard monthly in advance offering, and you may offer discounts on an annual basis. Of course, in terms of that flexibility, you can then look to structure the SaaS payment based on different types of criteria. So you may offer payments based on various levels of access, gold, silver, and bronze, for example, maybe based on features used. And particularly in the enterprise space, you may look to tie payment to authorized user numbers. And so in that way, all you need is a few large enterprise clients with substantial authorized user numbers. If you're able to structure a payment based on those authorized user numbers, you can generate significant cash flow and revenue. So then just talking more broadly on that authorized user issue, which is going to be really important in terms of the structure of the SaaS and the delivery of payment. Authorized users can be set up so that it provides a level of access management for the client, for yourself. And under the cloud-based solution, you have a lot of visibility over those authorized user numbers. You may choose to appoint administrators within those enterprise users. That has the benefit of empowering the businesses and making it a more marketable platform for them. But it also has the downstream benefit of minimizing some of that administration work. And of course, all the while under the SaaS product, you retain ultimate control over the entire use of the platform. So even though you're able to appoint administrators that have certain powers, that have certain ability to delegate and appoint and give authority to authorized user numbers, you're never really ceding any control over the platform. When there are authorized users or end users involved, you might want to consider putting in place end user license agreements or EULAs. Now, we've probably all seen those in various forms in our consumer lives. Typically, these are included as a click wrap form of agreement and something that the end user will just sign via clicking or confirmation before they use the platform. Under the enterprise model, you'll have an agreement in place with the business, but you won't have any direct documentation with individual users. So having a short, simple end user license agreement that they click through and acknowledge certain things around IP, around their restrictions of use, and around certain risk and liability points can be a really great liability and risk mitigation tool for you. Finally, and related to structuring payment and sort of tying payment to the level of service, it's quite common to incorporate the idea of service level agreements, or SLAs. This has the benefit from a marketing perspective for the SaaS platform of you being able to go to your customers or prospective customers and say, these are the service levels we commit to meeting. And they can be measured in any way, any shape or form. The most common typically are the level of availability or uptime versus downtime of the platform itself. Or of course, they could also be structured around incident response management times. And again, that's just something that you can go to the market with and say, we commit to providing these various levels of service. The flip side, of course, with making that commitment to your prospective customers and customers is some liability exposure. So when you do think about setting those up, firstly, you need to make sure that they're reasonable and you're confident that you can meet them. And secondly, you need to make sure that there are sufficient carve-outs or sufficient legal terms included within them so that you have the protection, for example, with respect to downtime. If the entire network falls down, then that doesn't count against you from a service level perspective. And that's obviously something that LegalVision assists its clients with to make sure they're fully protected from a risk and liability perspective. Another way you can mitigate some of that risk is we've talked about the importance of cash flow, particularly for new businesses. You don't want to be necessarily refunding clients and giving back that cash flow out of the business. So a common way we work with clients is to include service credits in the event that service level agreements are not met. And this basically means that, if the SLA is not met, that the customer gets a credit in the subsequent billing cycle. And so that's again a nice way of making sure that you're tying the service over through to the next period, but you're not bleeding that cash flow, which can be so crucial to new businesses. I'll now throw back to Jess, who'll talk us through some IP and privacy issues.
Yeah, okay. So intellectual property and data as well are both really important concepts when it comes to your SaaS business. IP and data are different concepts, they're separate concepts, but there definitely is some overlap. And we always cover off these concepts in separate clauses in your SaaS agreement. So intellectual property generally refers to creations of the mind. And in terms of your SaaS, your IP will include all of the code relating to the operation of the platform. It'll include the branding, the layout, the look and feel of your platform. So this IP is really what makes your SaaS business unique, and it's where a lot of the value in your business is found. So it's really important to make sure it's protected, and you can do this contractually through your SaaS agreement. As the owner of the IP, you can also choose who gets to benefit from your IP, and you can put in restrictions around usage. So typically your SaaS agreement will set out that you own the IP in your SaaS platform, and that you give a license or permission to your customers to use the platform. But only on certain conditions. So, for example, only on the condition that they pay the fees, only on the condition that they only let their staff or authorized users use the platform. They don't let outsiders use the platform. Only on the condition that they don't interfere with your platform, and on the condition that they don't try to resell the platform or do anything to breach any of your terms and conditions. So you also need to consider the ownership of any of the IP that your clients bring to the table that interoperates with the platform. So for example, with a lot of the SaaS businesses we see, that the clients or the customers can upload their own documents or their images or their branding to the platform. And in that case, you'll actually need a license from that customer to use that content. And so we need to see that license clause in the SaaS agreement, which sets out, what you can do with it. And certain customers who are very precious about their IP will want to see that that IP clause only allows you to use their IP in order to provide the SaaS, and that you're not going to use it for unlawful reasons. So your SaaS agreement also needs to deal with who owns any new intellectual property that's created through the use of your SaaS. So for example, if you run a SaaS business that's going to create a virtual garden using images that your customer has uploaded, you have to consider who owns the intellectual property in the virtual garden. Are you going to own it, or is your customer going to own that? It's really a commercial decision for you to make, but it needs to be reflected in the SaaS contract. In terms of data, so this, we're talking about information or data that might be stored on the platform or inputted into the platform or generated as a result of the use of the platform. So for instance, you might offer a SaaS that helps customers produce compliance reports or reports to measure your clients' CO2 emissions. So as with intellectual property, it's important that you carefully consider who owns what data and what rights you'll need to any data that's provided to you. A common example that comes up a lot is that our SaaS clients want to aggregate data that they receive or that they generate from the platform and then use it often in an anonymized form for analytics purposes. And they might use this data to further build the platform or to improve the platform. And so we need to see that analytics clause in the SaaS agreement, which sets out how the aggregated and anonymized data will be used. And larger clients of yours will often want to see and understand how you're using the data that you input or that is created from your use of the platform. And then moving to privacy rather. So privacy is a big one for any business. It's a really big one for SaaS businesses. So you'll need to consider what personal information is being input by your customer and how you're actually handling and storing that information. So your SaaS agreement should cover how the personal information will be used. What security measures do you have in place? What are you going to do if there's a data breach? And do you transfer personal information overseas? These questions will be really important to businesses in particular that need to comply with the Privacy Act. So it's important for you if your business needs to comply, and it will be important for your customers, and they'll want to see that you're handling the personal information that is involved in their business, including their customers and their authorized users. So they'll want to see that you're handling that information correctly. If your SaaS handles any particularly sensitive information, so things like health information, your customers, again, they're going to want to see that you're handling that information in accordance with the Australian privacy principles. So this means that you're not using it for purposes other than the primary purpose for which it was collected, or you're not using it without consent. And to sort of you should also have a privacy policy. So this is like a separate policy. It goes alongside your SaaS agreement, and it goes into a lot more detail about these privacy matters, and it should contain all of the things that are required under the 5th Australian Privacy Principle. Okay, so we've talked a lot about sort of risk factors. Paul's now going to speak about how to actually manage that risk and that liability.
Thanks, Jess. Yes, so far we've spoken about a lot of things that will have a lot of, have a large impact on the way in which you operate the SaaS platform and the service you offer to your customers, whether that's be from structuring payment through to making sure you're handling personal information correctly, through to your considerations about how you want to treat data and IP. Now we just want to bring some of those threads together and just talk about how, I guess, you could work with your legal advisors at LegalVision to make sure you're fully managing your risk and liability in the terms and conditions within the contract itself. So firstly, like any business, your SaaS business is not going to operate in a vacuum. It's going to be subject to a range of legislative regimes in place. And one of the really key things, particularly in the SaaS space where you're providing the SaaS service to consumers or to small businesses, is compliance with the Australian consumer law. So that will range from really basic things like not engaging in misleading and deceptive conduct, not making misrepresentations, right through to making sure that your contract does not contain any unfair contract terms. So we work very closely with our clients to make sure that the legal terms and conditions and the overall structure of the SaaS offering puts the SaaS provider in the best position from a risk and liability perspective. But there is a regulatory regime in place that is there to protect consumers. And one of the effects of that is we need to make sure that the terms are not too unfair for those consumers or small businesses. So even though a particular term or condition like a really far-reaching indemnity or a provision that seeks to exclude liability altogether would be very appealing for the SaaS provider in terms of managing their risk and liability, it may actually cause other problems from a regulatory perspective. And so we work very closely to make sure that all of the information around pricing, around the legal terms and conditions comply with that unfair contract regime. Having said that, we work within that regime, but we're still looking to make sure that the SaaS provider is put in the absolute best position when it comes to managing and limiting and excluding particular types of liability and risks. So one really important form of liability that we want to exclude altogether is the liability for consequential loss. Now, think of consequential loss as a form of liability that exists somewhat downstream from the direct loss. So if there's a breach of contract or some negligent act, or there's just think of it as being some problem or issue with the SaaS service itself. There are some direct losses that may be sustained by the counterparty, and the SaaS provider will need to be accountable for those. But we don't want the SaaS provider to be accountable for things like loss of profit, loss of opportunity, or loss of reputation. The two reasons why we want to exclude those types of liability are, firstly, they're a long way downstream, and the SaaS provider won't have a lot of visibility or foresight on what those types of losses are. And so it's not reasonable for the SaaS provider to be accountable for that type of liability. And secondly, because they can very quickly turn into large numbers. When we talk about things like loss of opportunity, loss of profit, and damaged reputation, the dollar figure associated with that liability can be very large. So consistent with market practice, we look to exclude that to the maximum extent we can under the law. And secondarily, aside from that point, we just like to limit the liability with respect to each user of the SaaS platform as much as possible. And for this, it's a bit less of a legal issue and more of a what is the market standard practice, and that will then flow through to whether or not the term itself is unfair for regulatory purposes. And so we work very closely with our clients to make sure that we're tapped into what the market standard is, and that we're reflecting that in a position that is protecting and limiting their liability to the maximum extent possible. And so an example may be that liability is limited equal to an amount of 12 months of the SaaS fees. It may be the 12 months preceding the event, act, or omission that gives rise to the liability, for example. But it's just a good way where you have a large customer base. It's a good way of managing risk across your customer base by seeking to limit, again, to the maximum extent permitted by law, the liability you have to each individual. And there's some particular wording, and again, this gets included in the standard terms and conditions, whether it's a document they sign up front, like Jess mentioned, offline, or whether it's included in the click wrap terms and conditions. It's very important that from an overarching sense, the liability is sufficiently excluded and restricted. It's very important for the ongoing solvency of the business in the event that the rainy day does arrive. Secondly, when we talk about providing particular warranties or promises about the services you're going to provide, it's really important that, again, we have reference to what is market standard and what is an appropriate level of promises that you will provide. We talked about earlier about making sure service levels were at an appropriate level, and again, the same principle flows down through here to the type of promises about the standard of service you're going to provide. So we looked to what is market standard, what is reasonable, and what is not unfair. Again, keeping in mind that we're providing the SaaS via the cloud, there are a lot of external factors in play here. So you don't want to necessarily, for example, promise that the SaaS will be available at all times, every time of the year, because there are factors beyond your control as a SaaS provider. And these are terms and conditions that are buried in the legal terms and conditions, but if something goes wrong, they're really important. So we work with our clients to make sure that we're striking the right balance there. And then finally, we want to include certain terms and conditions that tie everything that Jess mentioned about IP rights and data and privacy all through together. So we'll typically include certain restrictions, an obvious one being they're not able to, that your customers are not able to reverse engineer the software and try to recreate the source code. We'll make sure the terms and conditions with respect to the license you give them for use are sufficiently narrow and limited to their use of the SaaS platform, i.e. they can't try and commercialize it or on-sell it without your permission. And a range of other provisions that are just there to protect you so that, again, like I mentioned, if that rainy day does arrive, you're in a really solid position from a risk and liability perspective. Again, all things going well, all of the clients are really happy. There are no issues. The network never ever fails. But it is really important that the boring stuff in the terms and conditions is adequately drafted to protect you. So that's broadly it. If you have any particular questions on that, we'd love to hear from you, but I might throw it back across to Jess.
Yep, great. Okay, so I think we have a fact sheet available. So basically, if you've been sort of rushing to take notes as we've been speaking, this fact sheet basically summarizes what we've discussed it today. And you can access it via the handout section in your webinar panel. You might also be interested in joining our next webinar. So that's next Wednesday, the 13th of April. So our colleagues will be speaking about what to consider when buying your tech or online business. And you can register via our events page. The link is there. So let's get into some questions. We've received a handful of questions and feel free to keep sending them through. So I'll answer the first one. The first one we've got is which SaaS terms need to be included in a contract for a real estate platform? Okay, so I mean, all of the clauses and the terms that we've spoken about so far need to be included in your SaaS agreement for your real estate platform. I think a couple that are going to be particularly relevant for you are restrictions on scraping your website, your platform. You're undoubtedly going to have lots of really valuable information there, and you're going to want to make sure that there are some really clear restrictions and clauses that prohibit anyone from scraping that information or using the information and the content on your platform to build a competing platform or to build a database of property information. And you're also going to want to have disclaimers. I imagine that you might have things like property reports, articles, blogs on this sort of SaaS. And so it's going to be important to have disclaimers that the information in these reports is general in nature only, and it's not professional advice or legal advice that someone can rely on. So that's that one. Paul, is there a question you wanted to answer?
Sure. So the next one we got is, what is the difference between a SaaS agreement and a SaaS license? And basically, the short and the long answer is there's not really any difference. So a license, if we think of it more broadly from a legal perspective, is really just a right to use or a right to access. And typically, to make that enforceable, it would be included in a form of agreement. So just stepping back more broadly, I think across the market we'll see SaaS type services called different things. They might be called a SaaS agreement, a platform agreement, platform terms and conditions. They might be called a SaaS license. In some cases, they may even be called a software license. It doesn't really matter what they are called. What you will look at from both a general commercial and a legal perspective is what is being offered under the product and what the terms and conditions actually provide for. So there's no real difference between calling something a SaaS agreement and a SaaS license. And even in the SaaS agreements we draft, we incorporate the concept of license within them, particularly with respect to granting certain limited licenses with respect to access and use, and certainly limited licenses with respect to the use of IP.
Okay, I'll find another question. So there's a question here about EULAs. So do you recommend all end users sign a EULA? E.g., under an enterprise model, a company might expect all employees to download an app, but they haven't signed a SaaS agreement. Yeah, great question. I'd say yes, we generally do recommend that all end users sign a EULA, particularly if they're creating some sort of account or some sort of account is created for them as an end user to log on and use the platform. Often we see if the end users are accessing the platform via a mobile app, they'll accept or tick to accept some sort of end user license agreement before they can use the app. And it's just going to make sure it has those restrictions there that Paul mentioned. The fact that they shouldn't do anything to, anything illegal. They shouldn't upload any dodgy content. They shouldn't scrape the platform. They shouldn't try and reverse engineer it. And also making it clear that any content that they upload, that they give a license to the platform to use that content. I suppose another important thing that you might want to make sure is clear in an end user license agreement is what is going to be done with the data that they put in there. For example, in an employee context, an employee who's accepting a EULA might be transferring or sharing some information that they consider particularly sensitive or personal that they might not want to share with their employer. A EULA should make clear what's being done with that information. Of course, the employer should make that clear to the employee as well, just in case by chance they don't read the EULA, but the EULA will cover those sorts of issues as well. So I think that's that one. Yes, the short answer is yes, we do generally recommend all end users sign a EULA. And it doesn't have to be a big enterprise agreement, it can just be that short, simple terms and conditions. Paul, do you want to take the next one?
Sure. Got another question here. Would love to hear what market practice is for data ownership arrangements in the context of B2B SaaS arrangements or agreements. So that's a really good question. So I think the standard position is that the business customer will definitely retain all data that they input into the SaaS, and they'll typically give, from a legal perspective, a really limited license to the to the SaaS provider to use that data for the purpose of providing the service, and then sometimes we might try to expand that a little bit in some context I'll mention here. In terms of the data as it relates to IP of the SaaS provider, well, we advise and we try to make sure that the SaaS provider will always retain obviously all of the IP that's been developed in putting together the SaaS itself and the platform, but we also want the SaaS provider then to own any developed IP in any way whatsoever. And so we draft that really broadly so that if any new IP is generated in connection with the platform, whether it's sort of derivative works or improvements or enhancements, including whether they arise from feedback that's been given by customers, that's a really important thing. So if a customer gives feedback on a particular SaaS platform, and the SaaS owner then makes improvements to the platform, we want to make sure that the SaaS owner owns all of the IP and all of the data connected there. But linking it back a little bit more to data, I mean, certainly the customer will own all data, and typically, and certainly in more complex business arrangements, you'll see provisions included that allow for the customer to extract all of their data. So there'll be a positive obligation on the SaaS provider to extract that data and give it back to the customer in a form that is acceptable and readable to them at the end of the process. But any other data that is generated by the SaaS provider will be owned by the SaaS provider. And so a little bit then, I guess, the interface between data and IP, you might include provisions like the capacity for the SaaS provider to anonymize all of the data and generate analytics and improvements on the system. So, in short, to pull it all together, the business customer will own all of their data. Very rarely will you ever see that data will be provided across on an ownership basis to the SaaS provider, but the SaaS provider may look to use some of that data to generate improvements to the platform or to generate other products. and we would look to make sure that this SaaS provider had the full range of rights that would allow them to use that data and commercialize it, again subject to full compliance with things like the Privacy Act.
Okay, nice. Another question we have here is an interesting one. So it says, are you able to flip the context somewhat today and provide some insights into some of the more common contractual issues that may arise when contracting with SaaS entities? So yeah, I think this is a good question to discuss, because even as a SaaS provider, you may also be contracting with SaaS entities. So, I mean, a lot of the issues we've spoken about today are still important, but we're just viewing them from the customer's perspective. So I think a really big one is IP ownership. Yeah, as Paul said, as the customer, you're going to want to make sure that you continue to own all of your pre-existing and background IP. And if what the SaaS is doing for you is developing or creating some new intellectual property, and that's what you're paying for, the IP clause should reflect that. And that's one that can get you it can be glossed over because it can be complicated language, but we really need to make sure that the IP clause reflects the commercial arrangement. Another one is just the payment schedule. Make sure you're clear on when your fees are due. What's the situation if you want to cancel halfway through or terminate early? Do you have the option to do that? Now, the SaaS provider might have their own obligations to not include any sort of unfair clauses in their agreement. Whether or not they've done that is another question. So you need to make sure that, yeah, you're happy with the payment schedule and you're aware of your rights to terminate the agreement if you don't want to continue. I think it's important to make sure that you're not providing any warranties that you can't meet or any indemnities that are unreasonable. Usually when you're the customer in a contract, you shouldn't be providing too many indemnities under the contract. So it's important to look out for clauses that say, the customer indemnifies the provider for a breach of all clauses, something like that. That's probably going to be quite unfair and not something that you'll want to agree to. Another thing to think about is how important is this SaaS to your business? If it's a business critical SaaS that you're signing up to, you're really heavily relying on it in order to run your business, you're going to want to see those really solid SLAs that Paul mentioned, and you're going to want to make sure that they're going to, the sort of remedies available to you are going to be appropriate. And another, if you're relying on this business for, say, on the SaaS platform for compliance reasons. For example, are you a healthcare provider and you're using this as your patient management system? You're going to want to make sure that they're complying with their privacy obligations and that they're providing warranties that they are indeed complying with the Privacy Act. So yeah, a few things to think about there when you are the customer in this situation.
So another question here is, if you need a power of attorney for the platform, how do you include that in the agreement, or does that need to be separate? And so I guess if I interpret that as a question about whether the SaaS platform itself deals with powers of attorney and whatnot, that's one issue. But more broadly, I would just say, in response to this question, powers of attorney have very particular prescribed legal requirements for them to be binding and effective, and so they can be incorporated into the agreement, but it's just essential that I would say in this case that you work with legal advisors to make sure that the formal requirements of the power of attorney are satisfied. That they may be enabled to be incorporated into the agreement, or it may be used separately. Our general approach, whether in respect to powers of attorney or anything, is to try to get the agreement as streamlined as possible. But we're always conscious of where there is any sort of formal requirement, a formal legal document that takes precedence. So we're looking for as frictionless as possible in the contracting arrangements. But we never want to overstep the boundaries and risk things not being enforceable. So I hope that gives a little bit of guidance in respect to that question. There's probably a little bit more information in the background, but hopefully that gives a little bit of just some steering on that point.
Okay, well, I think we'll have to wrap up the Q&A there. Thanks so much for putting in your questions, and we can also answer any further questions afterwards. So hopefully what we've spoken about today has been helpful and informative for you. And if you are ready to get started on the legals for your business, we'd love to see you come on board as a LegalVision member. So you'll have access to our huge team of in-house lawyers, including Paul and me. So some of the exciting features of membership include that unlimited document drafting and reviews. So this includes the drafting of your SaaS contract. It includes trademark applications in Australia and New Zealand. It really includes quick turnarounds on all of this work. We get this done really quickly for you so you can move on. So this is essentially a membership for unlimited business legal services. So as a member, you'll be able to book unlimited legal advice consultations and get all of your business's legal needs sorted for an affordable monthly fee, and this just helps to ensure cost certainty. So webinar attendees are eligible to receive a complimentary consultation to discuss how we can help you with your SaaS agreement. So it's really easy to book. Just leave your contact details in the survey that will appear after the webinar ends. And you can also email the reply at email address on the screen and mention that you watched this webinar. So Paul and I look forward to speaking to hopefully many of you soon. That's all for today. Thanks so much for joining us.
Thank you.